And at 6:32, we're joined this morning once again by local defense attorney and legal analyst Patrick Cafferty. Patrick, prosecutors began making their case, though I thought both sides had their moments where they potentially scored points with the jury. How did you see it?
Good morning, Vince and Susan. So correct, we had what judges call opening statements yesterday, what lawyers call opening arguments. You saw two different styles. The state took an approach wherein they basically got up and told their story and told what they expected was going to happen. The defense took a very different approach. They laid out exhibits, including video, and told their story from start to finish. So some people have been critical of one approach or the other. The reality is sometimes they're different styles. We won't know until the end as to whether anybody scored points or what the jury thought of the opening statements. But one of the concepts is primacy. What the jurors hear first is oftentimes what they remember. And because the defense used video in their presentation, it may be that the jury will remember that defense presentation more clearly than they remember the state's presentation.
That's interesting. So, Patrick, in the defense opening statements, they hinted to the fact that Kyle Rittenhouse may be taking the stand in his own defense. In your opinion, why would the defense do that, and what are they trying to show to the jury?
Susan, that's insightful. Great question. In a case like this, if you think about the opening statements, there's not a whole lot that's in dispute here. Rittenhouse agrees that he ended the life of these two people. He almost ended the life of another person. He took shots at other people. At the end of the day, the jury is going to have to decide whether he acted in self-defense. And self-defense contemplates that the person who used force reasonably believed that the force he was using was necessary to prevent death or great bodily harm to himself. So a jury can look at the video, they can hear from witnesses, and they can then speculate, well, what is it that Kyle Rittenhouse was thinking at the time that he did this? The best evidence of what it is he was thinking and why he did what he did is going to come from Kyle Rittenhouse. If he can get on the stand and convince a jury that he had no choice but to take the action that he took, he will be acquitted on just about all of the charges. If, on the other hand, the jury believes that he is insincere, the jury believes that he had other choices and he was aware that he had other choices, they're not going to buy what he's selling, and they are going to find him guilty of those serious charges.
Patrick Cafferty, defense attorney and our legal analyst every morning. Patrick, thanks again for your time this morning and your insight. Really interesting.
Thank you so much. Have a good day.
You too.